not a person that constantly gets in trouble. I'm done with the drug use. My system is clean, so you have.
You could please this court, Brandon Bird, PA 3734, on behalf of Sean Odom. Mr. Odom, can you please state your full name for the record?
Sean Martell Odom.
Thank you.
You welcome.
In regards to the date and time set with limited examination, at this time, people are unable to proceed as to count one, whereas that count two and the added count three on the amended complaint be remanded to district court.
All right. As to the amended count 3, the domestic violence second offense, you waive formal reading of that charge, counsel, and your client pleads not guilty.
Yes, Your Honor.
All right.
Respectfully.
You need a copy of it?
Right, I never seen the amended complaint, Your Honor.
Today?
Yeah.
Oh, no, I'm kidding. Patience is my number one virtue.
Let's see.
Did you want me to pass it so you can go over that with your client?
Yeah, let me please.
Okay.
Your Honor.
So I'll pass the matter. We'll take him back, then you can go around and talk to your client. Oh, back up. And then why don't we put the waiver on the record if we could?
Good morning, Your Honor. Alexander, on behalf of the people, Your Honor, the people would waive any potential conflict between this honorable court and the office of the public defender. While the people don't believe this conflict exists, people make this waiver in avoidance of any doubt.
Your Honor, Lauren Brown, Deputy Chief Public Defender, our office would likewise waive any potential conflicts. We do not believe such conflicts exist in this honorable court hearing these matters. If a conflict were to arise, we'd waive such conflicts so that this honorable court could hear these matters.
Court, let's recall the case. People versus Sean Odom.
Alexander, on behalf of the people, Your Honor.
Yes, Your Honor. Brandon Bird on behalf of Sean Odom. Mr. Odom, can you state your name for the record again?
Sean Martell Odom.
Thank you.
You welcome.
All right.
Yes, Your Honor. We did get a chance to discuss this with my client. Understandable. We're gonna waive the formal reading and stay on mute.
All right. Court will enter a not guilty plea as to that count 3. Maintain his plea of not guilty as to count 2. Count 1 will be dismissed. I'll set a pretrial on counts 2 and 3 for May 28, 2025, 9 a.m. That is Judge Perry at the 15th District Court on the misdemeanor charges. All right.
Permission to address bond, Your Honor.
Figured you would. Go ahead.
Respectfully, we got the misdemeanor that was dropped today. It's the same complaining witness that's on this case that's just been dropped at the domestic violence second. So I'm not sure really how far this case is going to go, but that's something we'll see in district court. Essentially, my client has been in jail for since March.
About a month.
About a month. Roughly about a month now. Now it's pushed back almost 2 weeks, Your Honor, for 2 misdemeanors, which essentially could potentially be probationable, or
Yeah.
it's almost like he'd be serving a sentence if he stays in jail too much longer. One of these is a 93-day misdemeanor. I understand the other one's up to a year. But respectfully, we're gonna ask for a personal bond in this matter. He understands no contact with the complaining witness. He doesn't want any contact with the complaining witness. My client doesn't want to be sitting in the jail cell like
Well,
he is right now.
he had a personal and then messed that up.
Understandable, Your Honor, but now we're dealing with a whole new set of situations in which my client's been sitting in jail for a month now, almost a month. And I'm pretty sure a month in jail gives you a lot of time to think about where you want to be and where you don't want to be, and how you operate.
Go back to work.
Severe concerns that he can follow court orders. He did pick up that bond violation where he was in contact with the victim while out on bond and had another assaultive incident with her. And in this case, he had an assaultive incident with her and her child, giving the child a black eye. I also think because he's currently on probation in 15 for leaving with this same victim. So I don't believe he can keep himself from being in contact with her. And I have great concerns for her safety and her child's, given the facts of this case and his previous history with numerous dismissed DVs and convictions on DV.
Anything else, Counsel?
Respectfully, Your Honor, my client went to the police station. He went to the police station and made a police report in Ann Arbor. That's one of the reasons for the contact.
So just right, but here's what ended up happening. He had a personal bond. He didn't follow the conditions. He then came into custody, was arraigned, and the bond was set at where it is now. As a result of his failure to follow the condition. And then that is even really outside of the other stuff that the prosecutors indicated regarding the other contacts and other complaints that he has with the victim in the case. What I'm going to do is I'm going to deny your request to reduce his bond. You can take it up with Judge Perry, but at this point, I'll do it that way.
Thank you for hearing me out.
Oh, no.
Good morning, Your Honor. Student Attorney Kara Rosengren requesting to practice under Michigan Court Rule 8.120 under the supervision of Assistant Public Defender Hannah Apple on behalf of Mr. Kendrick. Could you say your name?
Taylor Kendrick.
So where are you from?
Me?
I know where he's from. I got all that information. I know where Apple's from. Yeah, you.
I attend Cooley Law School, Your Honor.
You do?
Yes.
Oh, a Michigander or you?
Yes.
What part?
I currently reside in Dexter, Your Honor.
So even a Washtenaw County, Michigan.
Yes, Your Honor.
Where are you originally from?
Oakland County, Holly, Michigan.
Yeah, kind of blew it there. Okay. Where'd you go to undergrad?
Western Michigan.
So you just never left the state?
I actually lived in Chicago for 15 years, Your Honor, so
Did you?
Mhm.
Didn't like it?
loved it, but came back for my husband's job.
Oh, he's to blame. All right. Permission to practice is granted. Welcome aboard.
Thank you.
In your honor, today's date talks about preliminary examination. At this time, people are unable to proceed as to count one and would ask that count two be remanded to district court.
You're moving to dismiss count one.
Yes, Your Honor.
People being unable to proceed as to count one is dismissed. I'll maintain the defendant's not guilty plea as to count two. Pretrial in this matter will then be set for
Judge Washington.
June 9th, 2025, 9 a.m. That is before Judge Washington. Thank you.
Thank you.
Bond will continue. Thank you.
Good morning, Your Honor. Alex Warren, Green on behalf of Mr. Sanders. State your name.
Bernard Sanders.
I have a plea form in front of me.
Correct, Your Honor. We are going to be proceeding on a guilty plea. Mr. Sanders is currently executing a sentencing judge waiver and the advice of rights form for the court.
All right. Plea form indicates that the defendant will be pleading guilty to an added count two of attempted resisting and obstructing a one-year offense. Upon his successful plea to that charge, count one would be dismissed. There's further the agreement of no delayed or deferred sentencing. That's the court's full understanding of the agreement.
That's our understanding, Your Honor.
Is that correct, counsel? All right, very good. May I have him sworn?
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give truth, the whole truth, and nothing but the true self you got? State your name.
Bernard Sanders.
All right, sir, it is this court's understanding that you are going to be pleading guilty to the charge of attempted resisting and obstructing a police officer. That's a misdemeanor punishable by up to 1 year incarceration or $1,000 fine plus court costs. Do you understand that, sir?
Yes, sir.
You understand also that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Barr in the 1482 District Court. You understand that?
Yes, sir.
All right. Still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Yes.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
Well,
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
no, Your Honor.
I'm sorry.
No.
Has anybody threatened you or forced?
No.
You're doing this voluntarily
Yes, Your Honor.
of your own free will?
Yes.
And because you believe that you're guilty of this offense?
Yes, Your Honor.
On the date of December 17, 2024, at the location 500 West Cross Street, City of Ypsilanti, Washtenaw County, State of Michigan, did you come into contact with a police officer from the Ypsilanti Police Department? What happened?
He asked me to get in the car and I ran.
I'm sorry?
He asked me to get in the car and I ran.
May I have what do, Your Honor?
Pardon?
Ma'am,
Yeah,
what-
go ahead.
Mr. Sanders, you were approached by a uniformed officer on that date at that location, right?
Yes.
And that officer informed you that he was investigating a crime, right?
Yeah.
And you began walking away, right?
Yep.
and he told you to stop
Yeah.
and you ran.
Yes.
Okay. You knew he was a police officer, right?
Yes.
Okay. You don't dispute that he was acting pursuant to his lawful duties, do you?
Nope.
Your Honor, I believe that lays a factual basis.
As the court complied with the court rule, would it be proper to accept this defendant's plea?
Defense is satisfied.
Court will accept the defendant's plea to count two. Count one is dismissed. Pre-sentence investigation and report is ordered at 14A2 probation. Sentencing will be
May 28th at 10 a.m.
May 28, 2025, 10
Yes.
a.m. before Judge Barr.
Yeah.
Bond will continue.
Thank you, Your Honor.
All right, thank you. Thank you, Mr. Chambers. Court does call the case of People versus Stephen Watson.
We're ready in this matter, Your Honor.
Good morning, Your Honor. Katie Rismersky. People.
Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Stephen Watson. Mr. Watson, please state your name for the.
Stephen Watson.
All right. What are we doing?
Your Honor, as the court is aware, this is time and place scheduled for preliminary examination. People are able to proceed this morning. I would anticipate a motion to dismiss the felony. I would be seeking a remand on misdemeanor, but I seek the court's guidance as well. It's charged as a DD first, and it should be a DD second. I apologize to the court of counsel that I do not have a DD complaint prepared, but I could move to add a count 3 of DD second or amend count 2, whatever the court's preference is.
Oh. Can we, Ms. Zenda is like an expert
I mean,
at getting those amended complaints done. And so I think Ms. Zenda might help you out
I
there.
think she's doing the things right now.
Oh, is she? Okay, see? So what I will do then is, and should we do that? I mean, it's my case, so I'll remember, but should we do that as a count 3 or just amending count 2?
Just amend the
Count 2, you think will work? Okay. So we'll just amend count 2 to reflect into DB second.
Wonderful. Thank you.
And you're waiving reading on that,
Yes, Your Honor.
and I'll just indicate that we'll maintain his plea to the amended count 2 in this matter of DB second. Count 1 would be dismissed as people are unable to proceed. I'll set a pretrial in this matter for
May 19th at 1 p.m.
May 19th, 2025, 1 p.m. That's before me.
Thank you, Your Honor. May we address the issue of bond?
Sure.
Honor, my client was out. He had difficulty and I believe there were issues with
Positive drops.
positive testing.
Get back to work.
My client does have employment. He is hoping that the job is maintained for him, but he does not think it will be maintained for too much longer past today's date. The felony charge was dismissed because there is no complaining witness. I expect there will probably not be a complaining witness at the court date as well. Based on that, Your Honor, I'd ask that my client's bond be returned to its previous state. My client has indicated that he will follow all of the strictures of the court. He has learned the importance of not indulging in drug use during any time period. He's asking that he be allowed to have his bond reinstated. The time he has sat in has taught him a valuable lesson.
The problem is that he was testing positive. That's part of the problem. The other part of the problem is he was supposed to then start CCOP and he didn't appear.
I talked to the agent and working a lot of hours. Told me to come to court and signed up for the COP or whatever, because I can do intensive outpatient treatment.
So, Your Honor, he did have contact, but the problem was at the time he was working a lot of hours and he had gone past the time when he should have been reporting. He did speak to the agent. Agent told him to come to court and then he could start getting into the program then. It's not that he doesn't want to. It's not that he intentionally tried to avoid what needs to be done. He set priorities with working and maintaining himself and his family. And that priority, as it turns out, was the incorrect. He has learned then what the priority should be. And again, it's not like he didn't make contact at all. He did do that. he was working. We'd like to continue to maintain that employment.
Okay, I don't need a response from the people. I'm gonna, at this moment, deny your request. I'll look at it again come the 19th, since it's coming back before me. It's just less than 6 days from now. I'll take a look at it. I would like to see something that's gonna keep him on track, because if he continues to doesn't do anything, we're gonna be right back in the same boat. So
I'm not going to use, my job is at risk and I'm full of positive drops and I can guarantee that. You know, I'm just trying to get back to work. My job is.
no, I hear you.
Yeah, just Simpson,
But-
I really learned my lesson. Like, you know, I understand like the importance of not dropping dirty and things like that. And I have learned my lesson. I don't need to be in here. If you give me a chance, I won't let you down. I really just trying to get back to work and
How many times do you think I hear that?
a lot, Your Honor, a lot. And I
So
guarantee,
tell me what makes you different.
because I got 6 kids, you know, I got a lot of things going on and I'm not a person that constantly gets in trouble. You know, I'm done with the drug use. My system is clean, so you have no problems with that. So if I drop today, drop next week before I come to court, everything could come back the same. And you got my word on that. Like,
So if I were to let you out, if I change my mind and I were to let you out, you test dirty or don't follow anything.
I would do the time in jail. But I'm
You're
not.
gonna do it right now anyway.
Yeah, but I'm not trying to do that. But what I'm saying is, I come back and plead guilty to everything. I'm just really trying to get back to work, and you won't have no problems out of me
I
after
think you
today.
need to get yourself set up with some type of outpatient.
Yeah, like and that's what I'm saying. If I go to community corrections today, I can sign up for the intensive outpatient treatment, so I can be able to get on the right track. But there
I'll
will
tell
be
you what, I'm gonna at this moment deny your request. However, if council would contact community corrections, see what they need, I will consider an order to release him with some strict compliance in their program.
See if they have something in place for you. Okay.
okay.
Oh, yeah.
Please.
So I'm not saying no forever, but I'm gonna need something that,
Thank you. Your Honor.
thank you.
So,
Thank you, Judge.
And after that,
On behalf of Mr. Stevens, Your Honor, say your name.
He's back.
Stevens.
Your name, sir?
Timothy Stevens.
Thank you.
In your date concept for preliminary examination, at this time, the people are unable to proceed as to counts 1 and 2, ask that count 3 be remanded to district court.
So you're moving to dismiss counts 1 and 2?
Yes, Your Honor.
Counts 1 and 2 are dismissed. I'll maintain the defendant's not guilty plea as to count 3. Set a pretrial in this matter for
June 5th, before Judge Rush Hour.
June 10th, you said? 5th, 2025, 10 a.m. I'm sorry. 10 a.m. before Judge Fresh Hour.
Thank you.
Yeah, on continue.
Thank you.
Thank you.
Katie Rosmerski for the people.
Yes, Your Honor, Brandon Bird on behalf of Deborah Gilmore. Ms. Gilmore, can you please state your full name for the record?
Deborah Gilmore.
All right.
Morning, Your Honor. People are unable to proceed at this point.
All right.
Respectfully request dismissal, Your Honor.
Your Honor, request a remand for this meeting.
All right. People being unable to proceed as to count 1, that is dismissed. I'll maintain the not guilty plea as to count 2. I'll set that for a pretrial on
June 9th at 9 a.m. before Judge Washington.
June 9th, 2025, 9 a.m.
Yes.
9 a.m. before Judge Wash.
Thank you, Judge.
Thank you, Bond.
Right.
Will continue. Thank you. Take care. That's it. Did that do it? Okay.
Good night, guys.
No. Not touch anything. Okay. Well, we got new equipment and didn't know how to work it, so. Cortez called Cage People versus Brandon G.
And is it on behalf of the people, Your Honor?
Assistant Public Defender Ben Dunawith on behalf of Mr. Gevers, who is standing to my right. Brandon, would you state your name for the record, please?
Brandon Gevers.
Your Honor. Yes, Your Honor.
So you're waiving your right to a preliminary examination?
Yes, sir.
You understand that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes, sir.
You understand that you'll not have that here. You'll proceed to circuit court for further resolution.
Yes, sir.
People also waive the right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on count one with two following.
Your Honor, we will waive the formal reading and stand mute.
Defendant having waived formal reading, standing mute to both counts. Court will enter a not guilty plea. Pretrial will be set for July 17, 2025, 1:30. Judge Slay.
Your Honor, could I address Ron briefly?
He's out.
He's out, but he's on a tether, and the complaining witness apparently lives thousands of miles away. So I don't think the tether serves any purpose, and we'd ask the court to take it off.
Your Honor, I just have concerns given the facts of this case. I'll leave it in the court's discretion, but I just have concerns given the highly valued factors in this case of strangulation. But she does reside out of state, Your Honor.
They're not in any proximity to each other.
No.
At all. It's just a GPS location track.
I would ask for if we don't leave the tether on until tomorrow. She is in state today. So I would have concerns for her safety while she's here and ask if the tether be removed tomorrow when she's back out of state.
Right. His bond will continue. What I will do is I send an order. We'll remove the GPS tether effective Friday.
Yes, sir.
Correct.
Thank you. Thank you, Judge.
Thank you.
Court does call the case People versus Sierra McCoy Nobles.
Good morning, Your Honor. Edward Drukes on behalf of Sierra McCoy Nobles.
Your name, ma'am?
Yeah, McCoy Nobles.
Thank you. This is a waiver.
That's correct, Your Honor.
Ma'am, you're waiving your right to a preliminary examination?
Yes,
And you understand that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
yes,
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
yes,
All right. People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on counts 1, 2, and 3 with 4 following. Mr. Jurgens.
Your Honor, we acknowledge receipt of the information, stand mute, waive reading, and ask for a pretrial date.
Defendant having waived formal reading, standing mute to all 4 counts. Court will enter a not guilty plea. Pretrial will be set for July 17, 2025, 1:30 before Judge Slay.
Thank you, Your Honor.
Bond will continue. Versus Lawrence Buckner.
Andrew Childers appearing on behalf of the people, Your Honor. Good morning, man. Please, honorable court, Kareem Johnson, on behalf of Mr. Buckner, approaching and seated to my right.
State your name, sir. Thank you. All right. Date and time set for preliminary examination. You may proceed.
That's correct, Your Honor. The people are ready to proceed. We intend on calling one witness, and the people call their first witness.
You may.
We would call Amy Hudson to the stand.
See you on the phone again. See you on his phone or no? Because you did that at the. Pardon? Council approach, please. Yeah, have her sworn.
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth, so help you God? See, state and spell your first and last name for the record.
My name is Amy. It's A-M-E-E. My last name is Hudson. A-S-O.
All right, you may inquire.
Thank you, Your Honor. And just one other matter. My officer in charge, Deputy Von Heath, is present in the courtroom. He's the only other witness I have present. I don't intend to call him, but he is present.
All right, good.
Miss Hudson, directing your attention back to the date of April the 1st of this year, 2025, were you in this courthouse testifying in a preliminary examination on a different matter?
Yes.
Okay. And was that in this very courtroom, courtroom C?
Yes.
Okay. And who was the judge at the time? Judge Washington? Okay. And was the defendant in that case, based on your understanding, Ms. Hudson, Mr. Buckner?
Yes.
Is he present in the courtroom here today?
Yes.
Can you identify an article of clothing that he's wearing?
He was wearing a black.
Okay. Your Honor, may the record reflect in court identification of the defendant?
Without objection, record shall so reflect.
Just, and I don't want to get into the facts of that case, but you were some sort of witness in that criminal case. Was that a criminal case?
Yes.
Okay, and you were a witness in it?
Yes.
Okay. And had you testified before Judge Washington in that matter on the date of April 1st, 2025?
Yes.
Okay. At some point, were you done testifying?
Yes.
Okay. After you were done testifying, what did you do?
I went and sat back down while they called up the next witness.
Okay. Where did you sit down?
I sat about where I was sitting when I stood up today, maybe one row up.
Okay, so we're making a transcription of this, so I'm gonna have to
I
be,
was on the right-hand side, probably in the third row back.
you're pointing in the courtroom, so you remained in the courtroom?
Yes, I remained in.
Okay, so you sat down in what we would call the gallery of the courtroom on, from where you are sitting in the witness stand on the right-hand side, and you said about the third row back.
Third row back.
Okay. And you did that while another witness was testifying. Okay. And at some point in time, did that witness stop testifying?
Yes.
Okay. What happened after that witness stopped testifying?
The judge asked for some more information and then she called for a break.
Okay. The judge stood up to take a break? Okay. Is that a yes?
Yes.
Thank you.
I'm sorry.
It's okay. And what happened when the judge stood up to take a break?
When they called the court for recess, he was on the left-hand side.
Who is he?
Mr. Buckner was on the left-hand side. He stood up. He was around two people that had already started to be in the row.
I'm going to just stop you right there. So you've said the left-hand side, that would be the left-hand side of the courtroom from where you are seated in the witness stand today.
Yes.
Okay. That would be the side that the defendants normally sit at?
Yes.
Okay. Where was the defendant seated?
He was in the first row back.
In the gallery?
In the gallery.
Okay, so he was not seated at counsel table?
No.
Okay. So the judge, the judge got off the bench and exited the courtroom?
Yes.
Okay.
Yeah, the judge, she did not exit the courtroom right away. She stood up, as they were calling. There was two people up front talking to her. And then when she got done speaking to them, that's when they called the recess. And he stood up.
He being the defendant?
The defendant, yeah. Went towards the middle. There was two people already going to go to exit. He waited until the sound went out.
Okay, when you say how do you know he waited until the sound went out?
Because he turned around and he looked. He stopped.
Objection, speculation.
I'm gonna overrule the objection. I'm gonna let her.
He stopped. He looked back. The minute
Hold on, look back at
at the
where?
screen, he looked back at the screen to make sure that the judge.
I'm gonna just,
Okay.
I'll stop you there. We're gonna unpack this a little bit. And Judge, I understand the court's concern. So you observed the defendant that he stopped. Where did he physically stop?
In the middle.
In the middle aisle? Okay.
Yeah.
Where was he in the middle of the aisle, close to what we would call the bar or close to the back door of the court?
He was in the middle, like closer towards this side of it.
Your motion, the right side.
The right side.
Okay.
Yes.
But I'm asking you, distance wise, was he in this area or was he in the back part of the?
No, he was closer towards the
front. Okay. You are still, fair to say, you are still seated in the third row.
I'm still seated.
On the right, your right side of the courtroom.
Yes.
Okay. When the defendant stopped, is he looking at you or is he looking somewhere else?
When he first stopped, he was looking like straight ahead.
Straight ahead.
and then he
And-
turned
Straight ahead toward,
Yeah,
towards the exit door.
towards the exit door.
Yes.
Okay,
And then when he stopped, he turned around and he looked.
and in what direction, when he turns around and looks, in what direction is he looking?
He's looking to see if the judge is.
I'm not, and so I'm not asking you, you can testify to things that you see, things that you hear, things that you witness. You can't testify to what someone else is thinking.
Right.
Okay,
No, he
so,
turned in the direction as to where the judge stand is.
okay, so just so we're clear, the defendant was looking towards the back doors of the courtroom. He then turned around and is looking in the direction of where the bench and the TVs are.
Yes.
Okay.
Yes, the bench and the TVs are.
At some point, does he then turn back around to look towards the back door?
Yes, he does.
When did he do that?
The minute the screen started making that sound.
Like a whoosh, white noise sound?
Yes.
Okay.
Yeah, like
And
it's no longer.
And I will direct your attention right.
okay, go ahead.
I'll direct your attention right now. There are screens on in this courtroom. You see those?
Yes.
And they're depicting the court and yourself in the witness stand. Is that correct?
Yes.
Okay. Did the screens look like that when the okay. What did they look like if
They
you look?
were like, as if cable went out, they were, there was nothing there. It said private.
Okay, it said private.
There's a black screen with private written in white.
Yeah,
Okay.
yes.
At that point, once the screens changed from showing the video of the courtroom to this private, what did the defendant do?
He walked on to the right-hand side, stopped to where I was sitting and, made verbal threats.
Okay, he said something to you?
Yes,
What did he say to you?
he called me.
I'm gonna stop you right there.
Yes,
Hold on a moment. You mentioned something and I just need to clarify this. You said that there was static.
yes, sir.
What was that you're talking about?
There was no more pictures showing. It was just like when you call up the lawyers to speak to you, the screen makes a noise. It makes it makes a noise. I don't know how to describe it. It's not it's not a silent noise. It makes a noise to where it's not recording anymore. Do you want me to sit down so you can turn it off?
No.
Okay.
I'm pretty much here every day. I'm just trying to figure out what you're talking about. You're saying it made a noise.
Yes, the screen went blank and it's not like it's crushing out a noise, there's a noise.
Coming out of the speakers.
Yes, coming out of the speakers.
Was it a constant noise?
It started and then I'll be honest, I don't know if it was on.
Gotcha. Okay. Just one other thing.
That's fine.
When you said Judge Washington was talking to two people, was she talking to two people in front of the bench or two
Yes.
people behind the bench?
No, two people in front.
So she was speaking to two people in front of the bench. All right. At the point at which she's doing that, can you hear that conversation?
No,
Okay, at the point at which she's doing that, do you hear anything in the courtroom?
no. I mean, I can hear people talk, but not up front. I mean, just what, people may be saying as they're sitting on the elevator.
Right. But do you hear anything else?
No,
Okay. And she had that conversation and turned around and left.
yes, yep, they call.
At the point that happened, what was on the screen?
Before, when she got done speaking to them,
Not as she's talking to them. What's on the screen?
there's nothing on the screen.
All
And then she got done speaking, and the video came back up before they called recess.
And when you say the video came back up, the video like it is right now?
Yes, and it
Okay.
just showed her on the bench. There was no one on the stand.
Okay, go ahead.
So at some point, as we've discussed, the defendant then turns and is walking, now facing back towards the back door,
Yes.
which would also be in the direction that you are in relation to the defendant.
I think he's just recapping what she's saying, so I'll overrule that. Go ahead.
Yes.
Okay. And you had previously said the defendant said something to you.
Yes,
Okay. What did he say to you?
he called me a lying bitch and told me that that he was gonna be even, he was gonna get me. That was the last thing he did, he was gonna get me.
Did you say anything in response to that?
No,
How did that statement by the defendant make you feel?
threatened.
After he made that statement to you, where did the defendant go?
He turned around, looked back one more time.
I'm going to stop you there just so we're clear. So the time he's talking to you, is the defendant looking towards the back of the courtroom or the front of the courtroom?
He's looking towards, well, he's looking at me.
Right.
At the exit.
Okay, so he's facing away from where the judge would sit.
Yes.
Okay. After he makes that statement, you said he turns around?
Yes.
Okay. When he turns around, in what direction is he now facing?
He's facing back towards the front where the judge would be sitting for
Okay.
this area.
At the time he turns around, is the judge on the bench?
No,
Okay. If you recall, at the time he turns around, who would be on, and I'm motioning on the other side of the bar, who were there attorneys or people present?
yes, yeah,
Okay.
his lawyer was still on the left-hand side. You guys are still on the right-hand side.
You guys being someone from the prosecutor's office?
Prosecuting, yes. And there was one officer also on the right-hand side, and there was one officer sitting out in the gallery, like 2 up from me.
Okay. So the defendant makes a statement to you, he turns around and he's now facing back in the direction of where the judge would sit, and what happens next?
The minute he saw that his lawyer was coming out, he turned around and took out the exit door.
Okay.
So again, speculations of what my client saw.
Okay. I would agree. So
Let me ask-
his lawyer, what you saw, ma'am, was his lawyer starting to leave and then he left.
Yeah. The minute
That's
he
what you, no, that's what you saw.
Yes.
Okay, thank you. I think that corrects it. That's what. Go ahead.
And did you remain seated in the gallery of the courtroom, or did you exit the courtroom at that point?
I remained seated.
Okay. And at some point after this fact, did you bring what had happened to someone else's attention?
Yes.
And who was
It
that?
was one of the police officers.
One of the police officers present in the courtroom?
Yes.
Okay. After you made contact with the police officer, did you have any further interactions with the defendant, Mr. Buckner? Okay. Certainly not in the courtroom,
Right.
correct?
Right.
Okay. Anything in the hallway of the courthouse?
No.
Okay.
No.
Mayor, one moment, Your Honor.
You may. While you do that, ma'am, you said you were seated in the third row. How far in on that third row were you?
Right there where the gentleman is with the black sweatshirt.
So you were seated on the end
Yes.
toward the aisle.
Yes.
Okay.
I have no further questions, Judge. Thank you.
Cross-examination.
Okay, ma'am, so you were here to testify, and if you remember, was that in case number 25 FB 1106, if you know?
I have no idea.
Did you get a subpoena to come to court to testify in that
No.
case? In that case.
I did not get a subpoena.
Okay.
They asked me to come and testify.
Now, it's my understanding that you're indicating that you are
Picking
seated
him up. Picking him up.
in the gallery of the courtroom right here.
Wow. Okay. Yeah, gotcha.
Is that correct? And you said that there's a member of law enforcement 2 rows up, sitting right here, where there's an individual with a sheriff's shirt.
Yes.
And your testimony to Mr. Buckner comes down the hall, the aisleway, stands at that same pew where the law enforcement officer was, and issues a threat to you, which would have been within 15 feet of the law enforcement officer.
I never said that. I said he stopped at where I was sitting and said something to me. I never at any time said anything that he stopped where the police officer was sitting in the pew.
So when he stopped, he was at your row,
Yes.
Picking him up.
but there was still a law enforcement officer 2 rows up.
Yes.
Was there other law enforcement officers in the courtroom like there are today?
One sitting up in the corner, up here on the right-hand side. where the gentleman is with the glasses.
When any of, I'm sorry,
Sitting where?
The gentleman with the glasses over here,
Mr. Bird?
yes, that's where the other.
Oh,
officer
on this
is.
side? On
Yes,
this side?
On this side.
On the right? Okay,
Yes.
go ahead, Council.
when this statement was allegedly made, none of the law enforcement officers in the courtroom jumped up and said anything?
No,
Now, you indicated that after you testified, you stayed in the courtroom.
yes.
Was there a sequestration order that,
Or what?
was there an order that you leave the courtroom after you finished testifying?
No,
Okay, so you heard the testimony after your testimony.
yes,
Mr. Buckner's lawyer at the time challenged the accusations that you made regarding Mr. Buckner, correct?
In which case?
In the case you were there to testify about.
Your Honor, I would object to what that other lawyer did. That would be hearsay.
I'm not asking for
Well,
what,
she's asking, I'll overrule that. I mean, he's not asking what she said. He's just asking what her impression of what he did.
right.
So, go.
His lawyer in the case you were there to testify on was challenging you on the assertions, allegations you made about Mr. Buckner.
for that case?
Yes.
Well, I mean, I don't know if he was challenging me, he was just questioning me the
Okay.
same as you are.
And there was another witness that came up to testify after your testimony, correct?
Yes,
You heard that witness's testimony.
yes,
You were there when the preliminary examination ended, correct?
yes,
That Judge Washington, found that there was no probable cause that Mr. Buckner committed a crime, correct?
I would object.
Well, Your Honor, the relevance is they've charged my client with intimidating.
I'm gonna overrule the objection.
Yep.
Go ahead.
Judge Washington found that there was no probable cause to believe that Mr. Buckner committed a crime after you testified, correct?
she also stated that it can be called back up if they get the proof that they need.
Okay, which is fair. All right. So after you made accusations about Mr. Buckner pointing guns at people, correct? Ma'am, I don't.
Answer the question, ma'am.
Yes, I did,
You made accusations that you saw him deliver crack from a great distance away? You didn't make the accusation? Did you make an accusation that you saw him point a gun at somebody?
yes.
Okay. No further questions, y'all.
I have no redirect, Judge. Thank you.
All right. Ma'am, how long did it take you to report this to somebody?
Within minutes.
Where was Mr. Buckner when you reported this?
He had walked out of the courtroom
How long after he walked out of the courtroom did you report it?
within probably 2 minutes, if even that,
To whom?
to the police officer passing by.
Which police officer? Is that officer here today?
Yes,
Okay, and that's who you reported it to?
yes,
That interaction, and if you look back on the right-hand side where the gentleman seated in the black shirt is, you're saying that's where you were sitting.
yes,
When Mr. Buckner came down the aisle, you'll notice that the back row is basically a handicap accessible row or a non-handicap accessible row. You see that where it extends out?
yes.
How close was Mr. Buckner to you when he's making these comments?
He was past where the gentleman is sitting with the black sweatshirt, and he was in between that row and the woman sitting right behind him. And he leaned back and
And he leaned back.
he looked, yeah, turned his head back and spoke to me.
So he's, because that's a little bit different than what you told me before, because you're saying that he was where the gentleman seated in the black
Right,
is, he was past him toward the door.
no, right, there's right where he's sitting, right there, at that spot, right there. It's like there's a spot, where you, not where you would enter, but where would be if you're standing beside. So closer towards the opening of the back row.
So he's standing closest to the opening of the back row.
Right, but he's beside where the gentleman is with the black sweatshirt. And that's where.
But so he's over on that side of the courtroom?
Yes,
So ma'am, are you telling me he's no longer in the middle aisle?
No, he crossed from the middle aisle to over to stand closer towards the right-hand side. He's no longer in the middle. He's standing like as if you're having a one-on-one private conversation with somebody.
And how loud were these comments you say he was making?
They were not very, I mean, other people were walking out of the courtroom. I could hear them, and it's not like he was screaming them. They were, I mean, they were normal voices.
When you testified in the previous matter, was there a victim's advocate assigned to you?
Yes, there was a victim's advocate.
Okay, so after you testified, did you talk to that victim's advocate?
No. They asked me to just go sit into the courtroom.
I want to go back, ma'am. At the time that you say Mr. Buckner got up, what's on the screens in the courtroom?
The screen was still on to where you could see where the judge was sitting. And then she called for a conference. And then the screen went blank. And then the screen went back up to where you could see where the judge was sitting. And then she called for a recess.
And then what happened to the screen when she called for a recess?
And then the screen went blank. And said, you know, right, it didn't show any pictures, didn't show any people anymore.
Prior to the judge taking recess, was it Mr. Buckner's other case that was being heard, the case that you were there for?
That case had been heard, and then honestly, I know that case was heard, there was a witness, but I think he was sitting out in the galley, and I think that they had started to call for another case. Because I don't think that.
Had your case that you were there on, had it concluded at that point?
Yes, because he was sitting out in the galley.
Okay. So then my question is that case had concluded,
Yes.
the judge had made a ruling.
No, she had asked for some more information, and they had set it aside for a minute and was gonna call it back up.
And so